So hi everyone, my name is Beth Mellon. I'm one of the supervising attorneys in Legal Aid's Housing and Law Unit. And I think I will go over a lot of this first piece, but I really welcome folks jumping in with questions or just like comments. I've heard a few things about stuff that folks are finding challenging about the new legislation, but feel free to unmute yourself or raise your hand, and then I'll see you or put something in the chat. So new eviction legislation, and I wanted to start just quickly with how did we get here? Why do we have new legislation with all kinds of new requirements? So as many of you may know, back in mid-May, Chairman Phil Mendelson, the chair of the DC Council, started pushing for changes to the eviction moratorium in DC and various tenant protections. And while that effort failed in mid-May, Mendelson then convened a working group. Several of our organizations and other organizations participated in that to discuss legislation along with landlords and some government officials to end the eviction protections. And meanwhile, in early July, Mayor Muriel Bowser, who has responsibility under local law for actually declaring a public health emergency, she had been given that authority by the council repeatedly throughout the pandemic, and she informed the council that she no longer wanted that authority and would not extend the public health emergency. And so at that point, the public health emergency was set to end on July 25th. And so there was a lot of emergency and temporary legislation, including a lot of protections for tenants related to eviction and a few other topics that have been tied to the public health emergency. And so just keep in mind any of those protections. At this point, the public health emergency lasted from March 11th to July 25th, and it is now over. There still is a public emergency in DC, but none of the protections for tenants have been tied to the public emergency as opposed to the public health emergency. And so, you know, at that point, really any hope of the council not acting disappeared, because the council really had to act at that point, and of course had for several months been considering winding down these protections. And so on July 13th, the council voted, and then the mayor subsequently signed the Public Emergency Extension and Eviction Utility Moratorium Phasing Emergency Act. I put links here to the emergency and temporary version. The temporary version has been approved by the council, but has to go through mayoral and congressional review. And I will edit this slide to add the effective date, but the effective date of the emergency is July 24th, 2021. And that shows up in subsequent slides. That is when the mayor actually signed the emergency bill. And overall, this is legislation that winds down the eviction moratorium and other tenant protections. It's what we're going to talk about today. So I'm not going to go over the following slide. And I also, have a handout with this table, but just so you have it in the PowerPoint slides, these are all the different dates for when landlords can take certain actions under the new emergency legislation. And we will be going over these as we go through the presentation. So we'll start with eviction. Eviction is most of what we will cover. Actual evictions, eviction notices, and new eviction case filings. And I understand we have some updates even from today that we've heard from some landlord attorneys. So when I get to that point, I'm going to ask folks who got those updates, if you're on, if you can share a little bit about that. So I've also put in statutory references on slides. And so everything that I'm about to go over, you can find in 3505.01K and 3505.01A, which is a separate statutory provision. And those cover actual evictions. So landlords have been prohibited from evicting tenants during the entire public health emergency. And this protection is one that was not extended. It is just over now. It's important here to note, owners actually have never been prohibited from evicting non-tenants. And so this specifically says tenants may not be evicted during the public health emergency. And so this comes up in several places. So when we say non-tenants, what I mean is folks like foreclosed homeowners, alleged, squatters, but that also could include cooperative members if they have no claim that they're a tenant. And sometimes those folks have benefited just as a practical matter, but some protections have applied to them, some have not. The eviction prohibition actually never protected them technically under the law. The court ultimately had set up a process where you had to get court approval or an order just so it would be clear that, this particular eviction applies to somebody who's not a tenant and should go forward. But as a practical matter, as we understand it, that never really kind of happened. There weren't actually any actual evictions. That was a relatively recent process that the court had set up. And so what does this mean? Legally, under the law, effective July 26th, after the public health emergency expired, landlords could start performing actual evictions. But it's more complicated than that because of the process the landlords have to go through. So the very first step is they have to get a date from the Marshal Service. And let me just say what the other two steps are, but then I would love, I know Lori had an update, and I think Brian Roja had an update from today. So they get that date, and that date is important because under legislation from a few years ago, tenants are entitled to know the actual date, not just a window. And so the notice generally under DC law is a 21-day notice with the date. There are a couple special protections for tenants who had been scheduled for eviction before the public health emergency. So this is someone, for example, their eviction was scheduled for March 16th, 2020, never happened. Those tenants get a 30-day notice, not a 21-day notice. And if it's a non-payment of rent case, and I should clarify that on this slide, I will do that before I send the slides around. For non-payment of rent, where this is relevant, there is an administrative order now from the court saying they have to get the current balance and or a current ledger. And that was something that was argued for because obviously it's been a very long time since March or April of 2020, and those balances are very different than whatever the last official notice to the tenant was. Let me pause there, and I didn't see if Lori was able to get on today. Lori, are you on? And if not, I don't know if Adam or somebody else from NLSP has the update that Lori shared. I'm happy to share it from what I saw in her email, but if anybody else has more information about it than me.
I only have the email. The exact same amount of information you have.
Well, do you feel comfortable going over it? Only because I'm going to be talking a lot.
Sure.
Thank you.
So Lori has a case with Brian Dorwin where there's an upcoming motion for judgment, and Brian shared some information about Afew Kerman's experiences with the marshals. He said that his clients had received emails from the Marshal Service canceling the evictions that they had scheduled, and saying that the marshals won't schedule any eviction until after October 3rd, 2021. He did say that he was confident that they would realize their mistake, but at the same time, who knows when the marshals would do that. And I guess, so that also does mean that they did have scheduled evictions and they canceled them. So both of the two kind of sides of that are sort of new information for us. Afew Kerman has not yet filed any public safety exception cases, though they had sent a handful of notices. And the court is not unsealing cases where a settlement has been breached and the landlord later gets a judgment unless the landlord affirmatively requests it, though I guess that the last ones may be less relevant to this.
Though nonetheless useful information. And sorry, it's hard for me to look at the PowerPoint and everything else. Brian Rohal, are you on? Awesome. Because I understand you also, I know Brian has been chatting from time to time, as many of us do, with Eddie Cordone. So do you have any other updates?
Just a small update. Eddie told me that, today that he had heard that the marshals are waiting for further advisement from the court. And so I think they're expecting an order from the court suggesting how to deal with the CDC order. So I think that's why everything's on pause. So, but it doesn't sound like they're saying that they will never again schedule before October 3rd, more just they're waiting for guidance.
Yeah, and so just to give a little context on that, I'll go into the CDC moratorium briefly, but the court last week had reached out, once this news of the CDC moratorium started coming out nationwide, had reached out to members of the LT working group, landlord and tenant attorneys, and asked for thoughts about the CDC moratorium. Does it apply in DC? What procedure should the court follow? And so those of us from, different organizations represented here who are on the LT working group and others came up with a response that we sent to the court. A couple landlords also shared some thoughts with the court. And so I think, we too are expecting that at some point the court will come up with some administrative order or something about how they will handle this issue. And so it sounds like the latest news as of today is the Marshals Service is just waiting for that to happen. I will say, I think we got an intake yesterday or the day before with a tenant who said they had a date, that the landlord said there was a date. And so it does sound like some landlords were given dates, and it may be that some tenants then come to us and say, hey, my landlord said there was a date, but perhaps that date, if it was given, has now been canceled or put on hold. So I think this is going to continue to be pretty confusing. On the CDC moratorium, there had been, as I'm sure many folks are aware, a prior version of a national eviction moratorium issued by the Centers for Disease Control and Prevention. It had not applied to DC because it does not apply in jurisdictions that have, stronger protections in place. And so I think generally it was not something that many of us in DC had worried about. And if anything, we were advising tenants kind of not to try to take advantage of it or file the required declaration. And I'll come back to that in a second. But what happened, that expired on July 31st. If folks may have followed in the news, there was a lot of pressure generated by Cori Bush and others to extend that moratorium. And so then on August 3rd, the CDC announced that they were, I'm not going to say extend because it's really reinstating because it expired for 2 days. And those people who might have been evicted on those days are just out of luck. Thankfully, nobody in DC is in that bucket as far as we know. But it was reinstated on August 3rd and lasts through October 3rd. I've put a link here to the order itself. It applies in jurisdictions that have substantial or high community spread of COVID-19. And CDC has an online map. Now, it's a little complicated. DC currently qualifies, but there's, as I understand it, a jurisdiction has to not qualify for a 14-day period to actually fall out of kind of coverage. I did see for folks who are on HJN, and I can try to amend this slide. I just saw this late last night. Someone shared a link for a website that apparently is going to track kind of the CDC data so that if you go there, you can put in your state and county for DC. DC is a state and county for purposes of this website to see if it's currently covered. And so that might be a resource we want to watch. And I know we were saying at Legal Aid that, maybe the supervising attorneys will just keep an eye on this and let folks in our office know and spread throughout the community. If at some point DC is not covered, we'll try to spread the word. And so I think for now it is safe to assume, DC is covered until you hear otherwise. The moratorium is limited in a whole variety of respects. So first of all, it only applies to actual evictions. And if you look at it and read it, you might think like, oh, evict and eviction are defined so broadly. Like, does it apply to notices? Does it apply to case filings? It talks about this a little bit in the order itself, but also the Department of Justice on behalf of the Trump administration, but now also the Biden administration, has been very clear in their court filings that they interpret it as only applying to actual evictions, that landlords can keep filing cases in court and proceeding in court, and it's only that actual act of evicting the family that is prohibited. And then the other thing is it generally only applies to non-payment of rent cases. Now, the way it's worded is a little weird. It says it applies to non-payment of rent and also any lease violations related to payment of rent or fees, which in DC, we think clearly covers consistently payment of rent. And then it excludes criminal activity, health and safety threats, property damage, and other lease violations unrelated to the payment of rent. And so there are some grounds for eviction in DC that kind of aren't really stated here. But for example, the order itself towards the beginning talks about it applying to non-payment of rent cases. I think, again, if you look at the administration's briefing on this, they talk about it applying to non-payment of rent. So I will just say this part is my commentary, but I think we would have a very tough argument that would be rejected if we tried to apply it to other types of cases. It is something we asked the court to weigh in on. You know, we pointed out this kind of ambiguity and said, hey, court, it would be helpful to the DC Superior Court. It'd be helpful if you all would clarify your view of which cases it applies to. To qualify, these are the requirements, and then a tenant also has to sign a declaration attesting to these. You have used your best efforts to get government rental or government housing assistance. Your 2020 or expected 2021 income is below $99,000, or it's $198,000 for couples, or you're not required to report any income to the IRS, or you've received a stimulus payment. You have to be unable to pay your full rent due to substantial loss of income, or you lost your job or have lower hours or wages, or extraordinary medical expenses. So it is not kind of the broadest statement of a COVID hardship. It is focused on those specific things. You also have to be using your best efforts to make as full a rent payment as possible. And bear in mind, you are attesting under oath that you will do that as a tenant. And you also have to say you will likely face homelessness or shared or congregate living if you're evicted. So you'll have to go into shelter, you'll move in with a family, or you'll just be homeless. And what the tenant has to do is fill out a declaration. It doesn't necessarily have to be the CDC form, but there is a CDC form. And I think our advice would be just use the CDC form in general. If anybody disagrees, please jump in on any of these things. You have to provide it to your landlord. And it is available online. It's in multiple languages. I think in particular, because you were saying I will pay my full rent as close as possible under the circumstances, and you're saying that under oath, if you have an ongoing eviction case, or you may face a future eviction case and you're not in court yet, that sure sounds like a statement a landlord would try to use against you potentially, or twist, you know, to make you look bad. And so I think the thinking of many of us has been, if you're not one of those tenants with a judgment and a writ, it's probably not a good idea to go ahead and complete and submit this form, because it only prevents an actual eviction. It doesn't really help you necessarily to, you know, be able to submit this. It doesn't give you any protection. And I saw Lucy ask this question in the chat, but, you know, our assumption certainly is that the reason the marshals are saying, you know, we may not do anything until after October 3rd is because of this CDC moratorium. That's the time period that it will be in effect. Do folks have any questions about that so far, about actual evictions? Because I'm going to move on to notices. And again, just feel free to put stuff in the chat and I'll keep trying to look at it every now and then. Oops. So eviction notices. Oh, let's see something in the chat. I mean, I think the time frame to sign the declaration, Jen Foster is asking, is there a time frame to sign it? I think the time frame is just before you're actually evicted. You know, once the landlord gets it, you should be protected. And, you know, I think we had said to the court that, of course, if a landlord has received one of those and the marshals call for a date, they should tell the marshal service, well, this person's protected, so I can't evict them. But, you know, we may have to assist tenants with seeking to stay their writs if a date gets scheduled, and then they either submit it after that, or they say, no, I've already submitted one. And one thing I'll mention, but I think it mostly doesn't apply to DC since this wasn't helpful before, is if a tenant did already submit one of the prior CDC declarations, there was a prior form that was very similar, then they're covered. And the CDC has said they don't have to submit again. The main difference between the prior form and the current form is the current form requires the tenant also to attest under oath, I live in a jurisdiction with substantial or high community spread. And it gives a link to the CDC map, but you know, there's been conversation, I know, among national advocates as well, that is very unfortunate that the CDC put something that is potentially intimidating and makes no sense for a tenant to have to attest to in the declaration, but it is. But if you happen to talk to a tenant who had already submitted one, they do not need to submit a new one. So on all of these things, I'm just trying to kind of go back over what had been the protection and then what is it now. So on eviction notices, there had been this protection. It was not from the beginning of the pandemic. The council didn't put this into effect until October 14th, 2020. that landlords were prohibited from sending eviction notices for the public health emergency plus 60 days after. And just to note, this was another one that only applied to tenants. And so, I'm not sure that owners kind of realized that. They may have stopped sending notices to non-tenants as well, but, non-tenants were still allowed to get notices. Effective May 3rd, there was a prior piece of legislation that created an exception for public safety cases, as folks may remember. And so landlords were allowed under that legislation to start sending these public safety lease violation notices starting May 3rd. And so now the new legislation creates dates for other types of cases. So when the legislation went into effect, which is July 24th, landlords were authorized to start sending notices about non-payment of rent and about a new exception, lease violations involving significant property damage. There are a few slides later on about what that exception encompasses. And I will repeat this later, but just to note, the notices for non-payment are now called quote unquote past due rent notices. That's the language in the law. There was a prior emergency temporary requirement for 30-day notices and non-payment of rent cases. And this emergency legislation got rid of that requirement for non-payment of rent cases, but then replaced it with these past due rent notices that we'll talk about. So that's more than a little confusing, but that is the state of the law for non-payment of rent. And then effective September 26th, landlords can send notices for all other types of lease violations or any other ground for eviction to a tenant. Now, all eviction notices have certain new requirements, and then there are kind of additional requirements for non-payment of rent. So this slide is any notice under the Rental Housing Act for eviction to a tenant. The tenant, it has to state prominently and at the beginning that the tenant does not have to vacate unless a court orders it. They have the right to dispute the allegations through court and stay in the rental unit till the court process ends. It has to include phone numbers for the Office of Tenant Advocate and the Landlord Tenant Legal Assistance Network and explain they're both resources for free legal services to tenants. And then for cases involving alleged violations of obligations of tenancy, it also has to say that the tenant has the right to correct or cease the alleged violation of tenancy and remain in the rental unit. I will just note, I think it's going to be really interesting what happens with that provision in one-strike cases, because those tenants do not have that right. And I am sure Lissa Dessel is losing sleep trying to figure out how she's going to square that. But there is nothing, in the statute itself that says that would not apply in one-strike cases. I suppose she could make an argument for preemption to say, like, look, because there's no right, I also don't have to tell a tenant there's a right and misinform them. So for non-payment of rent, these past due rent notices in the language of the statute, there is specific language, including a table of qualifying incomes in the DC code. And that is because Councilmember Alyssa Silverman felt very strongly that these should not be called notices to vacate or notices to quit, and that we need to tell landlords kind of exactly what to say and do it in language that is accessible and non-threatening. And folks can judge for yourself if you think that was accomplished with the language, but the language is in the statute. And then what the statute says is you have to include either this language that follows or substantively similar language. And I'm just summarizing here because it's like multiple paragraphs in a table, but it has to list the amount due. It says, I'm attaching a ledger showing the charges and payments for the period of delinquency. Note that language is very similar to the language in the LT Rule 10 about landlords having to produce ledgers in court. You have to advise the tenant they have the right to stay. If they pay, they have the right to defend themselves in court. Only a court can order their eviction, the OTA and LT Lane phone numbers. So that's all similar to the prior slide about all notices. Specifically advises the tenant about stay DC and also the emergency rental assistance program. It notes pre-pandemic balances. You probably need ERAP. And also to tell the tenant, I, the landlord, have started a stay DC application on your behalf. And then it advises the tenant, the landlord can file in court if you fail to complete a stay DC application within 60 days of getting this notice, or you're denied state EC for all or part of the amount due and you don't enter a payment plan within 14 days, or you enter a payment plan, but then you miss payments totaling at least $600 or 2 months rent, whichever is greater. And yes, Brian has a question. So Brian, you should go for it. And it's the prior slide.
The prior slide, slide 11, because I think that
Now
those are referring back to Q1. And if this is getting in the weeds too early, let me know. We can save it for the end.
Go.
Okay. So I think that these bullet points all come out of the language in 3505.01 Q1. And that Q1 section was originally created as the subsection dealing with the public safety emergency originally. That first section addressing the public safety emergency was in Q1.1. It was deleted and moved to a different part of the statute. Q1.2 remained, and Q1.2 says a notice issued to a tenant pursuant to this subsection must do the following, and do all these slides. The question in my mind is, what notice is issued pursuant to this subsection now? And so are we assuming that that means now all notices? Because originally it wasn't all notices, it was just for those, those exceptional notices.
That is a good question. And I think it may be a little ambiguous. Is it that subsection? Like, what does subsection mean there? And I think it would be better if it said section, meaning 501. And I don't really have a better answer than that.
I didn't expect that. It's just this. I have another spot too, on the next slide. There's some ambiguities that we just should be aware of. I think we're not going to answer.
Yes, no, please do, as folks see, and I'll try to remember to point them out. But there are places where there are ambiguities. You know, like I was mentioning the one strike right to cure thing, right? I think there are going to be all kinds of challenges and legal issues. You know, for example, going back to the non-payment slide, you know, let's say the landlord says, well, the tenant already applied for state EC, so I'm not starting an application. Or maybe they're like, well, just start another one just to comply with the statute, right? But are they allowed to say, like, you already applied for state EC, so that's what I'm advising you about, is you need to complete it. I think there are definitely going to be some nuances here where landlords try to argue like this doesn't quite fit. Another example is this talks about payment plans. If I'm remembering this correctly, the language in the statute for the notice generically talks about payment plans. Other parts of the statute specifically reference the pandemic payment plan legislation that is very specific. And so I think it's going to be a little unclear, and we pointed this out, but it is what it is at this point. You know, kind of what does this offer of a payment plan really mean? Is it only the tenants who you know, have a right to a payment plan under that pandemic legislation? Although nothing here says they have to enter a payment plan. It's, you know, it's really framed in terms of if the parties do not reach one within 14 days, and then there's this kind of separate parallel requirement in some cases for some balances to enter a payment plan. I'm gonna keep going, but folks keep putting stuff in the chat or just unmute. So I mentioned, you know, they deleted language, and it's very subtle, but it's in there for the prior requirement for a 30-day notice to quit and notice of claim for non-payment of rent. And then for all notices, going back to all notices, there are a few new requirements. If the landlord knows the tenant speaks a primary language other than English or Spanish that's covered by the Language Access Act, they have to provide it in that language. And if the notice is served by posting, the landlord has to provide a time-stamped photograph of the service by posting to the court. So that was notices. Any questions about notices? I will keep going if I don't see questions or hear questions, because there's just a lot of stuff here. So eviction case filings, I think an important thing to point out here is this is 16-1501. This does not just apply to tenants. When a landlord sues a foreclosed homeowner, a quote unquote squatter, we would argue a drug haven case. In the landlord tenant branch on form 1A or 1B or 1C, they are filing under the forcible entry and detainer statute 16-1501, and this applies to all those cases. And so that's why this says, you know, it generally applies to all eviction cases, including for non-tenants. So owners have been prohibited from filing a new complaint during the public health emergency plus 60 days. That is now being changed. And on drug haven cases, there has been an argument raised because there's some specific statutory language in the drug haven statute that says, notwithstanding 161501, da, 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 and that issue of drug haven cases is just unresolved. And it may come up because of the date set forward here. So prior, in terms of the dates, prior legislation said as of May 3rd, landlords could file new cases for the public safety lease violations. They, of course, had to send a 30-day notice first. So I think, it was only into June that we saw those getting filed. And I know some of the first hearings were scheduled for this week. But this new legislation amends the prior prohibition, keeps in place that public safety exception, and says, here's some new timelines. July 24th, when the new legislation went into effect, landlords can file cases for this new exception for significant property damage. And again, we'll have a couple slides in a minute about what that is. October 12th, they can file for non-payment. January 1st of next year is everything else. And so that's why, for example, on drug haven, I anticipate we may have some issues where landlords say, well, hey, it doesn't apply to the drug haven statute, I can apply sooner. We may have some folks who file complaints against foreclosed homeowners and say, like, for some reason this doesn't apply. I think that's just wrong because it applies to any forcible entry and detainer action. I think some of the things we've seen during the pandemic where ejectment cases have been filed or other types of breach of contract cases, we may continue to see since there's still this prohibition on filing an eviction case. And then also just keep in mind the notices can still go out. So unfortunately, we will have tenants who get these notices, and even though they can't be sued, they will have all the fear and harassment and so forth that was experienced before the notice prohibition went into place. When filing a case for non-payment of rent, landlords have to document at the time of filing that they complied with certain requirements. So the landlord has to apply for or initiate an application for the tenant for stay DC, specifically stay DC. Tenant has to be notified in writing of that pending application. Note, it does not say the landlord has to notify them. And so I think, some landlords might try to argue, hey, if they got an email telling them it's been done, that's enough. But of course, the notice itself for non-payment rent cases separately tells them that. But the wording there does not say the landlord has to be the one to notify them. And then the landlord has to be eligible to file a case under 350501B1. That provision says there is past due rent that is $600 or more, and one of the following applies. The tenant did not submit an emergency rental assistance application within 60 days of receiving the past due rent notice. That does not say stay DC. It says generically emergency rental assistance. The tenant's application was denied or it was approved, but it left a balance of $600 or more, and the parties did not enter a payment plan within 14 days, or there's a tenant with a payment plan and they are at least $600 or 2 months behind, whichever is greater. So under those circumstances, and it's October 12th or later, landlord can file for non-payment of rent. The tenant also has to be served with a notice that meets the requirements in 3505.01B12, which were requirements in a prior slide, and all other requirements of district law. I know Gabby had mentioned to me there have been some questions of like, what does all other requirements of district law mean? It was intended just to be a catchphrase. So, it's things like it has to be in a language other than English or Spanish where required. It has to be in English and Spanish as a matter of district law. It has to be served in this way. It has to, when you serve by posting, you have to meet these other requirements. So it was really intended just to be clear that like, even if you meet these new requirements under the law, that does not somehow absolve you of all other requirements under District of Columbia law. I see Ashley has a question. Are there provisions that require the landlord to cooperate with stay DC, or are they just required to initiate or file? And the answer is they're just required to initiate or file. I will say if the tenant's application is held up in the process, including because the landlord's not cooperating, if that's delaying things, it protects tenants in a lot of circumstances. And that we will get to that in a future slide. So I'll save that for then. But yeah, there's no other obligation on landlords other than to either apply on behalf of or initiate a stay DC application. I think so, Brian. Brian's question in the chat is, does the catch-all language include having a registration or exemption number on there? I think so, but I will say, like, I also don't think this provision is intended to create kind of new rights with respect to that. You know, it's just like, hey, there's already something that says the registration or exemption number has to be there, so you have to do that too. There's nothing here that's telling you you don't have to do that anymore. But I don't think it like creates any necessarily kind of new right or process for that, or isn't intended to anyway.
Yeah, the reason I ask is Silverman's language doesn't say that the notice language in B1 doesn't say anything about a registration requirement in there, and where the statute does require it, it talks about a notice to vacate, I think, but not a notice of past due rent. And so that's where we may have fights about whether a notice is valid if it doesn't include one of those things. Okay.
No, I think that that there are some ambiguities there as well. So I appreciate you pointing it out, Brian. They do have to document and this is also in a future slide. So let me, because it may even be on the next one, I don't remember. They have to document the registration or exemption at the time of filing. So there are various ways that cases can get dismissed. This slide covers affirmative defenses if the tenant can establish it through testimony. So, you know, these are things where the tenant's going to have to be there. They're going to have to testify. It's an affirmative, put some onus on the tenant. So the landlord did not pursue rental assistance timely or in good faith. The tenant didn't receive notice of the rental assistance application. On that one, just note, it doesn't say the landlord didn't provide it. It says the tenant didn't receive it. Landlord did not provide notice that meets the requirements of B1-2 that we were talking about before, or other requirements of district law. So that goes back to what we were just talking about, Brian, that I think, you know, it may be ambiguous, kind of, does it have to be on the past due rent notice or something else? But I think a tenant could raise this when they get into court on a motion to dismiss and say, the landlord didn't provide a notice that meets these other requirements, therefore, but it's ambiguous. Tenant or their authorized representative submitted an emergency rental assistance application prior to or during the 60 days from that past due rent notice, and it's pending, approved, and awaiting payment or under appeal. I just want to emphasize here, that's for tenants who submitted it prior to or during that 60-day period. So it is going to be very important when tenants get this notice, and the notice has to give them that precise date that's the 60-day expiration. They really need to, if at all possible, submit that application during that 60-day window, because otherwise this technically does not apply. And maybe they can convince the court, you know, to do something else, dismiss or give them more time. But once they miss that 60-day window after the past due rent notice, they're going to lose some rights. The landlord hasn't met the requirements of 501(b)(1)(1). That's the one that says $600 or greater in one of the following. And then if they are rent arrears that accrued since March 11th, 2020, and the landlord did not offer or negotiate a payment plan in good faith at any time since March 11th, 2020. And so that is the payment plan legislation. And so if the landlord did not offer or negotiate in good faith a payment plan, and that's the one that covers rent due during the pandemic or for 1 year after, then the tenant can raise that as an affirmative defense and get the case dismissed. And it does say requiring dismissal once the tenant establishes one of those. Now, those were the affirmative defenses. These are not affirmative defenses and do not require the tenant to be participating in the case. Although we may, you know, of course, have some arguments about this. So the first one says no tenant shall be evicted based on complaint under this subsection. That subsection is public safety, significant property damage, or non-payment filed before January 1st, 2022. So once we hit next year, there will be an argument this does not apply. The court has to determine by a preponderance of the evidence for violations of obligations of tenancy that they meet the requirements. And I should say, I should take out the non-payment things. This part is for violations of obligations. I'll fix that on the slide. So this is exactly the same as language in the drug haven statute that the court has interpreted to require an ex parte proof hearing. So the hope is they would likewise require an ex parte proof hearing under this statute, given that similar language, even if the tenant defaults, that the landlord will have to prove something ex parte proof. And then for non-payment, the following provision: at the initial hearing, if the complaint does not allege sufficient facts or the person aggrieved has not produced sufficient documentation to meet all those pre-filing requirements, then the court shall dismiss the complaint. So that should apply even if the tenant defaults. I think something, that we will want to talk about, I'm sure the supervising senior attorneys will talk about and share wisdom, is when we are doing court observation, how do we want to kind of, keep an eye on that for cases where tenants do not appear, because we will want to make sure that the court is really following these provisions, which are intended to provide at least some protection, even if a tenant does not show up. Let me just peek at the chat. Oops. Chat. I don't see anything. So there are other restrictions on eviction cases. Non-paying rent has to be $600 or more. The landlord has to have a valid basic business license for rental housing and have a valid registration or claim of exemption. And there is an exception, though, if the landlord says they were unable to obtain or renew a rental housing basic business license based on extenuating circumstances. It does say these requirements, so that can be interpreted to mean both, not just the basic business license, but also the registration or claim of exemption, that those are waived. I think that's just a little bit of poor drafting that none of us caught. And so I do think it's a little confusing how that's worded, that like the exemption is focused on basic business license, but it says, quote unquote, these requirements, referring to both sets of requirements above, are waived. So maybe some interesting things that come up about that. That was because landlords were saying that DCRA, they used to do these provisional BBLs, basic business licenses, if they couldn't inspect a unit, but now they're not doing that. And so landlords are saying, hey, even if the tenant is the reason that they can't inspect the unit, they will not give me a basic business license. And I think mainly that would apply, right, to landlords, and they shouldn't be doing this, but they don't have a basic business license. They have a tenant in place. They're then trying to evict that tenant, or I think they would say it could happen with a quote unquote squatter, non-tenant as well. That person's not cooperating. And so I can't get the basic business license. And so they wanted to be able to file something in court and say to the judge, here are the circumstances. I can't get that basic business license. I should be allowed to proceed. And then on consistent late payment of rent, for consistent late payment of rent occurring between March 11th and 60 days after the end of the public health emergency, which is September 23rd, payments within that window cannot be the basis for a consistent late payment of rent case. I know there have been some questions raised about tenants applying for state EC for future months and not paying while they await their application, and that they will be charged late fees, or they could be making themselves vulnerable to consistent late payment of rent. I kind of wonder on consistent late payment of rent, at least, if them notifying the landlord, I'm making this application for future rent, therefore I'm going to wait to hear and I will not be paying you for September, could help kind of ameliorate that, because it has to, under the case law, be willful, and there has to be a pattern. And so I wonder if tenants can take some of the wind out of that on consistent late payment, at least by telling the landlord I'm applying for future rent. And of course the landlord should get notice, but I don't think their notice they get initially through state EC tells them it's for future rent. And so anyway, once we get to October rent, that might be something to think about. No chats yet. And I know we're getting close to the end of the hour, but we're also getting close. A lot of this is about eviction. Landlords also have to comply with a new service requirement 30 days before the initial hearing, excluding Sundays, legal holidays, days during the public health emergency. Public health emergency is now over, but there's also language that says, hey, you can serve during the public health emergency if it's one of these exception cases. And I don't know, I don't think we have time to talk about like the state of arguments about service during the public health emergency, but for future cases, I think it's at least pretty clear. If a summons is served by posting, landlord has to submit a timestamp photograph of that service by posting to the court. The public safety exception, I just want to focus on the changes. So I put the information in the slide, but there were a couple important changes. one of which was snuck in, and I will say I don't think any of us realized it till this was being voted on, which is they did extend it to threats to residents of immediately adjacent properties. We had specifically excluded that when this was originally drafted, and they got it added in. And then the other thing I would just point out is eviction notices, have to meet the other requirements. They had been required to be served on the Office of the Tenant Advocate, and I think OTA decided they didn't like that. And so that requirement is gone. And so for cases kind of falling in this interim period, it would still be there and maybe would be a basis for dismissal. All the, just as we were talking about, there are other requirements under DC law, and you can always try to argue for dismissal. But as of July 24th, they do not have to do that. And then the other thing I just want to point out, there are still some limits on these public safety cases that tenants have to get offered some things, but it used to be they have to be connected to as opposed to offered, and now it's just offered. But also the lead-in language for this provision in the statute focuses on evictions that happen during the public health emergency, despite the general prohibition during the public health emergency. My reading of this part of the statute is it just doesn't apply anymore. It's still there, but I don't think it's going to apply because it was limited to evictions being carried out during the public health emergency, which is now over. In any event, at this point, it would just be an offer of different services, which I think could be accomplished by handing a tenant a flyer with a list of phone numbers. So I don't think this is very helpful anymore. And it was only for those public safety cases. I see a question in the chat. Oh, nice. So Natasha's just saying that she was able to win a motion arguing that a landlord cannot bring a consistent late payment of rent case as a matter of contract law if that was not explained in the lease. That's awesome, Natasha. Those are always the bane of our existence. All right, so I have a few more slides here. So the significant property damage exception, this is also found in 16-1501. This is a new exception. So it applies to large holes in the wall that can't be repaired with plaster and paint, destruction of major building systems such as electric or plumbing, destruction of appliances like ovens, refrigerators, or dishwashers, damage to large areas of flooring. And so, this is not the best drafting in the world, and we tried to improve the language, but it is what it is. I think clearly some landlords were complaining about specific situations, so they wrote a fairly specific statute. Although it says, significant property damage includes, so it could include other things, but I think that's an illustrative list. And then they did add an affirmative defense requiring dismissal if the tenant can establish with quote unquote substantial evidence that the housing provider willfully or negligently contributed to the significant damage that is the subject of the complaint. And so I think that was just aimed at situations where, the landlord somehow is kind of complicit or contributorily negligent in whatever happened. I am just going to quickly finish the last part here, and these are a little more straightforward, hopefully, or mostly. Late fees. Late fees were prohibited for any month during the public health emergency, not extended over now with the public health emergency. So as of August, landlords can start charging late fees again. Rent increases. This one is a little tricky. Let me just see. I see there's a chat. The property damage one, there's no reason kind of it wouldn't include. And I think the cross references, I would look at it specifically, Brian, just to make sure I haven't missed something. But it goes to your question about kind of cases under this subsection, maybe in some of those requirements, but there's nothing that kind of exempts them from a 30-day notice or the opportunity to cure. And sorry, Brian's question, I'm trying to remember to repeat the questions for the recording, was for the property damage exception, do you still have to provide a 30-day notice? Does the tenant still have an opportunity to cure? And certainly nothing in the statute removes those rights. And I think there are places of cross-reference where you can say, hey, they're clearly referring here to a 30-day notice, and 30-day notice also has to talk about the opportunity to cure. I think the rent increase prohibition is actually a little tricky, although I'm not aware of landlords necessarily having tried to make any arguments about it. So landlords had been prohibited from issuing a rent increase notice to tenants during the public health emergency. This has been extended until December 31st. They can start on December 31st. And I assume they picked that date on purpose, thinking 30-day notice, it can go into effect in February. So this is in section 904 of the Rental Housing Act. 904 applies to all tenants, not just those in rent stabilized housing, but I put the specific language here because it talks about no housing provider can issue a rent increase notice. And so I think there will be an argument that if a tenant is not entitled to a 30-day notice, this does not protect them. And so then the question is, well, which tenants are entitled to a notice? Well, there's a prior section in subsection in 904 that requires a 30-day notice for increases, quote unquote, under the Rental Housing Act. What does that mean? I think to me, there's a good argument that only applies to rent stabilization because they're the only rent increases that are regulated by and under the Rental Housing Act. But instead you could say, hey, the Rental Housing Act governs all tenancies. That's any rent increase. And of course you can have, as a matter of contract law, a provision in a lease. And I think that's somewhat common that a tenant's lease can require a 30-day notice. And so, I personally think we should argue this applies to all tenants, but I think it's important to appreciate, as Brian's questions have done, there are places here where I think there are arguments landlords may try to make. And just looking at the plain language of the statute, it is a little tricky. There's probably some better way they could have done this, but certainly the intent of putting this in section 904, with the prior provision and this current provision was to apply to all tenants. I think it's just a little tricky, did they do it in the right way? And then finally, tolling of tenant deadlines. Deadlines for tenants and tenant organizations to exercise their rights under the Rental Housing Conversion Sale Act, which covers TOPA and condominium conversions, and the Rental Housing Act, have been told during the public health emergency for 30 days. That was not extended, so that continues through August 24th, and then it goes away. I think there are a lot of questions about scope here as well for the Rental Housing Act, hopefully clearly applies to petitions under rent control, for example. Or potentially even filing a tenant petition. Although the rent administrator has not been proactive in enforcing that. But I think there may be an argument that, for example, if the tenant has a right to cure and them curing is exercising that right, then they got a prior notice that that was told. I don't know that that will really matter because at this point, if you're filing a new case, in theory, you have to give a new notice and new opportunity to cure in any event. And yes, Esther is asking a question about the rent increase. I think this is actually a really good question, Esther, about the rent increase provision. I think the argument for tenants with a housing subsidy, if they're not entitled to a 30-day notice as a matter of federal law, would be preemption. So it's not that it doesn't apply on its face. I think on its face, it does apply to tenants with subsidies. And, in most circumstances, those tenants are entitled to a 30-day notice under federal law, federal regulations or federal statute. But where they are not entitled to it under federal law, I would certainly think there is a very good conflict preemption argument that you cannot apply a local law that would require something different. And same for before December 31st. And so that's been the case throughout the pandemic, that this rent increase notice, it doesn't explicitly exclude subsidized tenants, but where you have a federal subsidy, for sure, there would be a conflict. Even for local subsidies, there's probably a general versus specific argument where they would say, you could say the specific requirements of the subsidized housing program, that your rent goes up if your income goes up, and I have to give you a notice, governs over a general prohibition on such notices. Does that make sense?
Yes, thank you.
Yeah. I think it's an an interesting, there are some places like the low income housing tax credit program, for example, where it's not clear that federal preemption would apply. So there may be some tricky issues there. And then the final thing is just tenant payment plans. I just stuck this in here just to mention, nothing has changed on those. So that had always been a requirement for tenants who owe rent during the public health emergency and for 1 year after. And they have not extended those provisions, but they also haven't changed them. So they're just going to be in effect through July 25th of next year. And that is it.
Beth, I have a question, and you may have already said this through your explanation, which, by the way, thank you so much. With regards to this payment plans, how would that work in conjunction with the requirement of both applying for state EC and not filing a case more than $600? And kind of like the, and then the provision that you mentioned, or that, that's stated in the law, that if they are acting in bad faith by not providing or engaging in good faith in coming up with a payment plan. Like, for me, there's a little bit of a disconnect. I think if I think about it a little bit harder, I'll probably get it. But again, I have you here, so I think I'll just ask you.
Yeah, no, I mean, I don't know that I have a really good answer as opposed to kind of a general way of thinking about it. Because I think they need to comply with both unless they conflict. And the defense about a payment plan is fascinating because it says at any time, if the landlord did not offer one or negotiate in good faith as required. And so, I think if at any point, if you have a tenant who at any point, says, oh, in June of 2020, before we had state EC or a bunch of rental assistance money, I asked my landlord about a payment plan. They said, I'm not doing that, right? This law suggests the case has to be dismissed and it doesn't really have a backstop to protect the landlord, which is awesome. But I do think it creates some weird situations. I think that, they have to comply with both. And so, for example, if there's a payment plan in place, but they haven't applied for state EC, they have to apply for state EC. I think you can imagine situations where a landlord applies and the tenant doesn't qualify or doesn't owe rent during the time period, has already gotten state EC, right? Like it may be an empty application in some situations, but the law doesn't specifically create an exception. And that's where I'm wondering if we'll see landlords come in and say, well, I didn't apply because they don't qualify or whatever. And then I think the court will just have to decide, do they take the statute literally and say, it doesn't matter, you still had to apply. Like that might be a reason it'll get denied and then you can sue them. But the statute says for every tenant you apply. So even if there's a payment plan, even if they don't qualify, et cetera, et cetera, et cetera. But I'm sure we will see situations that raise those kinds of questions. Does that help, Esther? Is that the kind of stuff you were thinking about?
Yeah, that is. And it is helpful. Another thought that I had was it could also apply in situations where the landlord and the tenant engage in a payment plan outside of court. And if the tenant defaults on there, they would still then in that situation also have to apply for state EC before they file the case. So yeah, I can see it. Okay, thank you.
Yeah, I agree. And I will say there's now a conflict between the tenant payment plan legislation said you cannot sue a tenant if they're under, unless you've offered a payment plan, given them a payment plan, and then they've defaulted. And the new eviction law is now a little more specific to say the default has to be at least $600 or 2 months rent, whichever is higher. There again, I think there's a potential conflict between those two provisions. And so if you have a tenant who did a payment plan, is in default, but it's not $600 or not 2 months, and let's say they do all the other things, they apply for state EC, they do the new notice, blah, blah, blah. There may be a question there where the landlord will say, well, like under the payment plan legislation, it just says if they're behind, I get to sue. But the more recent, more specific legislation has a different thing. And, some of these things, right, frankly, are just, this was a really long thing. And I will say personally too, like there are just some things we didn't catch. There are conflicts. At this point, it is what it is.
Thanks, Beth.
And I see, I'm just going to read this out loud for the recording, that there is also just a comment from Rachel saying she's had state EC approve and pay pre-pandemic balances on 3 occasions when she put the entire pre-pandemic balance in April 2020 in the state EC application. And I know some stuff has circulated about this, but we also know there are still some limited ERAP funds available through Housing Counseling Services and some other providers,